Welcome. My name is Zachary Cook. I'm a law student at the Indiana University Maurer School of Law. This video is part of a three-part series designed for attorneys and prisoners who file lawsuits without the assistance of a lawyer. This final installment of the series will discuss the exhaustion requirement. I'll be explaining its purpose, and I'll offer several cases to show how courts treat the requirement. The exhaustion requirement of the PLRA says that no action shall be brought with respect to prison conditions by a prisoner confined in any jail, prison, or correctional facility until such administrative remedies as available are exhausted. The purpose of this requirement is to notify prison officials of a prisoner's issue and provide them with an opportunity to resolve the issue before a lawsuit is filed. If they're able to do so, the amount of time spent by the parties and the courts on prisoner litigation should be reduced. The basic concept of satisfying the requirement is simple. Each prison has a system for addressing and resolving issues. If the prisoner brings their issue through the entire system, but their issue remains unresolved, the prisoner has exhausted their administrative remedies. Only then may they file a civil rights claim with a court. However, case law in the last 2 decades has added some nuance to this basic rule. In Booth v. Cherner, the Supreme Court held that the exhaustion requirement applies regardless of the fit, or lack thereof, between the prisoner's requested relief and the relief available to them. In other words, as long as the prison system has some way to relieve the prisoner's issue, it doesn't matter that the prison doesn't provide the specific relief that the prisoner wants. The administrative remedy will still be considered available, and the prisoner must try to use it before bringing a lawsuit. This issue can come up particularly where a prisoner seeks monetary relief, when the prison grievance system does not allow such relief. In Porter v. Nussel, the Supreme Court ruled that the exhaustion requirement applies to all lawsuits relating to prison life, whether the suit is about general or specific instances. Therefore, if a prisoner is challenging anything that has happened to him in prison, be it his medical care, the conditions, the food, an incident of force, he must exhaust his administrative remedies before filing a lawsuit. In Woodford v. Noel, the Supreme Court held that strict compliance with the prison's administrative grievance process is required. This means that a prisoner must comply with the rules and deadlines set forth in the prison's grievance process. While strict compliance with an institution's grievance process is required, an inmate is not required to exhaust administrative remedies that are not available to him or her. In Ross v. Blake, the Supreme Court gave 3 examples of when administrative remedies would be considered unavailable. First, an administrative procedure is unavailable when it operates as a simple dead end. When there is no potential for any relief, the inmate has no obligation to exhaust. Remember, however, that exhaustion is still required even if the process does not provide the particular relief the inmate wants. Second, a remedy is considered unavailable if the administrative procedure surrounding it is so complex or confusing that a reasonable prisoner would not be able to understand it. Finally, a remedy can be considered unavailable when the prison administrators threaten or misrepresent the grievance policy requirements, thus thwarting the complaint process through their own actions. For example, in Hill v. Snyder, the Seventh Circuit held that if an inmate requests a grievance from a staff member who, pursuant to the grievance policy, is required to provide one upon request, and the request is denied, the inmate need not ask other staff members for a grievance form in order for remedies to be unavailable. Similarly, administrative remedies may become unavailable if prison officials fail to respond to an inmate's grievance. Take note that a particular institution's grievance policy may provide procedures that an inmate should follow, such as requesting to move on to the next level, if they don't receive a response within a specified timeline. In short, if an inmate has attempted to exhaust his administrative remedies, but has been unable to because of circumstances out of his control, those remedies may be unavailable, and he may not be required to complete the grievance process. Our final case, Jones v. Bach, states that failure to exhaust administrative remedies is an affirmative defense. If the defendants raise this defense, it will be considered before the merits of the claims are developed. It is the defendant's burden to prove that the plaintiff failed to exhaust his administrative remedies and that those remedies were available to him. In addition, the exhaustion requirement only demands that the prisoner complies with the prison's grievance system, nothing more. Thus, the level of detail necessary in a grievance is defined by the grievance policy requirements, not the PLRA. Where the administrative policy is silent, a grievance suffices if it alerts the prison to the nature of the wrong for which redress is sought. An offender need not lay out the facts, articulate legal theories, or demand particular relief, so long as the grievance objects intelligibly to some asserted shortcoming. Finally, total exhaustion is not required. Under a total exhaustion rule, the entire lawsuit would fail if even one claim had not been exhausted. The court rejected this rule because it would incentivize filing separate suits for each claim, which would only clog up the courts. Each prison system will have a different administrative remedy process. The grievance process in federal prison and Indiana State Prison is provided in a handbook called the Recruited Counsel's Prison Litigation Handbook. This book is available to download online in PDF form. By now, you should have a good idea of the exhaustion requirement, what it is, when it applies, and how it works. Thank you for watching this video.